A very good evening, everyone. Myself, Shauradip Odhikari. It is my immense pleasure to welcome you all to today's enlightening webinar related to a very important topic organized by Modok Trainer Academy. The theme for today's evening is both crucial and insightful: rainbow of Indian marriage laws and the scenario on prohibition of child marriage. This topic not only highlights the legal nuances surrounding marriage laws but also addresses the critical issue of child marriage, which continues to impact lives across our country. Now, I would like to share a few words with all of you about our today's eminent speaker. Today, we are delighted to have our distinguished guest, Shri Debabrata Dey, with us. He is an advocate attached to the Calcutta High Court. He has an exemplary academic background, having completed his master's and LL.B. from the University of Calcutta, along with an MBA in finance and HR. Additionally, he holds a PG diploma in counseling and has done basic and advanced courses in graphology. In his earlier professional life, Shri Debabrata Dey held top-ranking positions with Government of India in various states. Following his voluntary retirement, he dedicated himself to independent law practice. Beyond his legal endeavors, he has a deep interest in spiritual activities and has attended classes at the Indology Department of the Ramakrishna Mission Institute of Culture at Gol Park, Kolkata. Currently, Sri Debabrata Dey is associated with reputed socio-legal organizations at both national and international levels. He contributes to society as a legal advisor, management consultant, well-being counselor, social worker, honorary teacher, and orator on diverse topics of interest. His dedication to serving individuals and society is truly inspiring. This session promises to be both enlightening and thought-provoking. I encourage all attendees to actively participate and gain insights from Shri Debabrata Dey's vast expertise and experience. So without further delay, let us begin this enriching session. Please join me in extending a warm welcome to Shri Debabrata Dey. Now, I humbly request to Shri Debabrata Dey, sir, please start your valuable lecture.
Sir,
মাইকটা
unmute
অফ
yourself.
আছে।
Sir, unmute yourself.
It is okay.
Okay.
Acha. Thank you, Shorudeep, and hello and good evening to all the viewers. I know law is a very boring subject, but marriage, it is not at all boring. It is dhamakadar, mazedar event, as we see in our everyday life, Hindi movies or Hindi Bengali serials. So I shall try to blend between the two. Okay. On my next part, I shall discuss very important and interesting subject on the position of child marriage in our country and state and various provision of prohibition of child marriage. So my topic, rainbow of Indian marriage laws and scenario on provision prohibition of child marriage. What is the marriage? That is the main question. What is the marriage? Actually, there is no definition which adequately covers all types of human marriage. It has given a number of definitions and explanation. I can say here some of them only. Okay. Edward Westermark, philosopher and sociologist of Finland, in his History of Human Marriage, defines marriage as the more or less durable connection between the male and female lasting beyond the mere act of propagation till after birth of offspring. In short, it is said like that. Edward Westermark, philosopher and sociologist of Finland, in his History of Human Marriage, defines marriage as the more or less durable connection between male and female lasting beyond the mere act of propagation. I have already said this. Next, I am telling you. Polish and British anthropologist Malinowski says that marriage is a contract for production of maintenance of children. Another point, according to the George A. Lundberg, an American sociologist, marriage consists of the rules and regulations which defines the rights and duties and privileges of husband and wife with respect to each other. According to the sociology by Horton and Hunt, marriage is the approved social pattern whereby two or more persons establish a family. These are some of the definitions which are bookish definitions only, but in our everyday life, we know what marriage is. Now I will go to the legal perspective on Indian and global scenario. The right to marry is a component of right to life. Okay, right to marry is a component of right to life under Article 21 of the Constitution of India. Constitution of India, Article 21 says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Okay. So this is the right to marry is a component of right to life. This right has been recognized under Universal Declaration of Human Rights 1948. Okay. Article 16 of the same states that 3 points are there. Men and women of full age without any limitations due to race, nationality, religion, have the right to marry and to found a family. Okay. They are entitled to equal rights as to marriage, during the marriage, and at its dissolution. Men and women, equal rights. Next point. Marriage shall be entered into only with the free and full consent of the intending spouses. It is a very important thing. Free and full consent of the intending spouses. Third point, the family is the neutral and fundamental group of units of society and is entitled to protection by the society and the state. The family is to be protected by society and the state as per Universal Declaration of Human Rights 1948. So these are the legal perspective. Now, rules of the marriage. Marriage, as we know, is a very important social institution. Social institution, very important. A family is the most basic social unit in human society. We are all living in human society, and family is the most basic social unit. And the family is formed by a group of people who are related by birth, marriage, or adoption. Okay. That is why no society allows a couple quietly to pair off. and start living as husband and wife. They cannot do that without forming a designated family. Why? Because marriage brings a number of obligations as well as privileges affecting many people, not only those two people who are marrying each other. Marriage brings a number of obligations as well as privileges. Okay. Every society has therefore developed a pattern for guiding marriages. Uh, Common marriage laws. These are the three important elements in common marriage laws. What are the elements? Willingness to be married and remain married. Willingness to be married and remain married. Continuous living together as husband and wife. Whenever I like, I live together. Whenever I don't like, I do not live together. That is not the common practice. Another thing is this: holding out to the public that the couple is husband and wife. That means society should know that they are the husband and wife. One husband and wife has to show themselves to the society that we are husband and wife. For marriage, most important step is to choice of mates. Though there is no standard laid down for choosing of partner, yet from time to time, rules have been made to regulate the selection of mates in human society. Actually, anyone cannot marry any other one. This is the important thing, which I will discuss afterwards. Choice of mate, choice of partner is the important thing in the marriage. Anyone cannot marry any other one. Now, Indian marriage laws. As of now, there are 7 marriage laws in this multiracial and multi-religious nation, India. Okay, that's why I have given the topic heading as rainbow. 7 marriage laws, and there are similarities and dissimilarities and variety of colors and shades. And with these, all these Indian marriage laws. What are they? First, Hindu Marriage Act 1955, Social Marriage Act 1954, Christian Marriage and Divorce Act 1957, Parsi Marriage and Divorce Act 1936, Foreign Marriage Act 1969, Jammu and Kashmir Marriage Act, and Muslim Marriage Law. I am repeating these 7 again. Hindu Marriage Act 1955, Special Marriage Act 1954, Christian Marriage and Divorce Act 1957, Parsi Marriage and Divorce Act 1936, Foreign Marriage Act 1969, Jammu and Kashmir Marriage Act, and Muslim Marriage Law. Now, I will mention important points of these laws. Among the above mentioned laws, first 6 are statute-made laws, except the Muslim marriage law. This is the last one. First 6 was statute-made laws. That means these are the acts passed by the Parliament of India. Okay. 6 laws, which I mentioned one by one up to 6, these are passed by the Parliament of India. But Muslim marriage law is not governed by any act of legislative outline, but governed by the dictates of Holy Quran and Sharia. That is the important thing to be noted. Second important thing, while Hindu Marriage Act, Christian Marriage Act, and Parsi Marriage Act are personal marriage laws. Personal marriage laws, that means which are based on individual religious identity. Hindu, Christian, Parsi. These laws are based on the individual religious identity. Whereas Special Marriage Act is a secular marriage law. Secular means intra-religious. Okay. Further, Third point, while Hindu marriage, Christian marriage, Parsi marriage are sacramental, sacred, holy. On the other hand, marriage under Special Marriage Act is contractual. It is a contractual marriage. So also the Muslim marriage. Muslim marriage is also contractual. What is this means? In case of first three marriage laws, that is Hindu marriage, Christian marriage, and Parsi marriage, religious and customary rituals are obligatory. Obligatory, that must have to done. While in case of last two laws, that is Special Marriage Act and Muslim marriage, performing rituals are optional, not mandatory. Rituals may be or may not be done. Now, each of the above laws, that is in BR Act, provision of solemnization as well as dissolution do exist. First part, how to solemnize the marriage, and second part, dissolution. What is dissolution? Dissolution means separation, divorce, maintenance, etc. But here I shall give an overview on the general aspects regarding solemnization of Indian marriage laws, keeping aside the dissolution part here. Only first part, solemnization, with the intention to have a positive vibes on the marriage in life, and obviously for time constraint. Because if I want to discuss everything, 1 hour is not sufficient. Dissolution in each law is a big chapter and need a full separate episode. So I will omit for this for today's session. Okay. Now I will go the marriage acts, what I have mentioned earlier, one by one. I will go through elaborately for Hindu Marriage Act, Muslim marriage law, and Special Marriage Act. Elaborately, I will mention, and other marriage laws. I will give an overview of that. Okay. Hindu Marriage Act. Hindu marriage is governed by Hindu Marriage Act 1955. And it applies to any person, obviously, who is Hindu by religion. Obviously, Hindu Marriage Act is for the Hindu by religion, and in any of its forms of Hindu. What does it mean? That is within the extended meaning of Hindu, that is Buddhist, Jaina, and Sikh. They are also under the purview of Hindu Marriage Act. In fact, Hindu Marriage Act applies to all such persons domiciled in India who are not Muslims, Christians, and Parsi, because for them separate marriage laws are there. This is the first thing. Now, for Hindus, marriage is a sacrosanct union, holy union, sacred union. It is also an important social institution. Marriage in India are between two families. We understand that marriage in India are between two families rather than two individuals. Society as well as Indian legislation, judiciary attempt to protect marriage. Society, legislation, and judiciary attempt to protect marriage. That's why the dissolution part is long one, lengthy one, and if that is to be done, a lengthy process is to be followed. Now, arranged marriage and dowry are customary in Hindu marriage. Although dowry is still in force as custom in various sections of Hindu society, although there is an act, namely the Dowry Prohibition Act 1961. Dowry Prohibition Act 1961 is there, but even then dowry is still in force in custom of Hindu Marriage Act. Okay. Now, essential conditions of Hindu marriage, which is stated in section 5. The bridegroom has to complete 21 years of age and the bride has to complete 18 years of age at the time of their wedding. This is very important. There is an age limit for bridegroom and bride. Neither party has spouse living at the time of marriage. So, second marriage is not permissible when the spouse is alive. The couple should not be prohibited relationship unless their customs permits them to get married. I have told in no one can marry anyone. That is, there is degree of prohibited relationship, which is given in section 3G of the Act, that within the list, no one can marry. The couple should not be shopindos, that is, shogotro, unless their custom permits them to get married. Shopindo relationship given in 3F. Within the list, no one can marry other. Both the parties have sound mind and stable mental order for giving valid consent. That is, we have seen in the Universal Human Right Declaration, isn't it? Now, what are the essential ceremonies of Hindu marriage? Section 7. A Hindu marriage may be solemnized in accordance with the customary rights of either party, bridegroom or bride. Even a simple ceremony of exchange of garland, tying a thali, that is Mangal Sutra, Sindur Dan, Homa, or putting a ring upon a finger is sufficient to constitute a valid Hindu marriage. These things we are seeing in the marriage, Hindu marriage generally. But the following are the essential rights which it is said to be common requirement of all ceremonial marriage. What are they? Invocation before the sacred fire and Shaptapadi. What is Shaptapadi? Taking 7 steps by the bridegroom and the bride jointly around the sacred fire. That also we see that bridegroom or bride are moving around the sacred fire. It is the common requirement of Hindu Marriage Act. Another point, Kannadanam, giving bride to the bridegroom, is not essential ceremony. Although the system is invoked in many communities as custom. We see this also, Kannadanam is still invoked, but it is not essential ceremony. Essential ceremony is Shaptapadi and invocation before the sacred fire. So this is the essential ceremonies. Now registration of marriage. Registration of marriage under Hindu Marriage Act is not compulsory yet. Understood? Registration of marriage under Hindu Marriage Act is not compulsory yet. However, registration of marriage is beneficial to the parties, and as such, there is provision of registration of marriage under Section 8 of the Act. Hindu Marriage Act, Section 8, there is a provision of registration of marriage. But that can be done, may not be done. But the National Commission for Women says the following benefits of marriage registration. There are benefits, and National Commission of Women said these are the common benefits. So many other benefits also. That is, what are they? Prevention of child marriage. Because when the registration should be there, the age of the spouses, except the husband and wife, is to be document is to be submitted. Check of bigamy, polygamy. Help women exercise their matrimonial rights. Enable women to claim inheritance because they have the certificate. With the certificate, they can claim the rights. And deter men from deserting their wives. These are some of the benefits I am telling here, but there are so many other benefits also. However, non-registration of marriage does not render the marriage invalid under this act. Apart from the provision of prevailing legislative law, this is the legislative law, Hindu Marriage Act 1955, the normative texts, dharma texts, and some Griho Sutras classify marriage into 8 different forms. What are they? Brahmo, Daivo, Arsha, Projapataya, Osura, Gandharva, Rakshasa, and Poishacha. We see in the Ramayana and Mahabharata era, such type of marriage were there. These forms are accordance with Manusmriti and the Sanatan Hindu law, but they are not a statute-made laws. These are the Sanatan Hindu laws. These 8 different forms are there, but they are not statute-made laws. Statute-made laws, 1955, I have already told. So this is the Hindu Marriage Act in short. The Bare Act is a good number of pages are there, but in short, I am telling this. Now I will go to Muslim marriage law. Hindu Marriage Act, after that Muslim marriage law. Marriage, that is nikah, an Arabic word, under Islam is a matrimonial relation and an institution which legalizes the sexual activities between a male and a female for the object of procreation of kids, promotion of love, mutual support, and creation of families which are considered as essential unit in the society. So these are the purpose of marriage in Muslim law. Just like Hinduism, Islam is also a strong advocate of marriage. However, Muslim concept of marriage differs from Hindu conception. Why? Muslim marriage is a civil contract, not a sacrament. Although, according to many philosophers, marriage in Islam is a religious duty. Please let it be noted that there is no prescribed form for contract. That I am telling now, the contract is to be done. No prescribed form. The contract is known as nikah nama. And also, no religious ceremony is required as per law. As per law, it is not required, but there are ceremonies. Muslim laws has been derived from various codified and uncodified sources like Quran, customs, urf, precedents, and various legislations. Now, essentials of Muslim nikah. Differences from Hindu marriage. So, I am telling general essentials of Muslim nikah. Muslim marriage. Parties must have capacity to marry. The husband and wife. They must have the capacity of entering into a contract. Muslim who is of sound mind and who is attained the puberty may enter into a contract of marriage. Sound mind and puberty. What is puberty? Puberty means the age at which a person becomes capable of performing sexual intercourse and procreating children. In general, it is for girls, it is 9 or 10 years like that. You see, Indian Majority Act has not touched here. So, this is the first point. First difference is there that in other marriage laws, minimum age is mentioned, but here puberty is the criteria. Next, proposal from one party and acceptance from other party is required. Free consent, both the parties. Proposal is called ijab and acceptance is qubul. Third point, a consideration meher means a sum which is payable by the husband to the wife on marriage. It may be prompt or deferred. The meher system is for the protection of women. Here is a difference also. Dowry in Hindu marriage, it is given by the generally from the wife's family to the husband's family. But here the consideration meher is given, is payable by the husband to the wife. Understood? So there is a difference between Hindu Marriage Act and Muslim Marriage Act. The nikah in the Islamic marriage ceremony, whereby Muslim couple legitimize their marriage in the eyes of God by signing the marriage contract in the presence of an imam and at least two major witnesses. In Sunni law, two major witnesses are required. But in Shia law, however, no witnesses is mandatory. If there is witnesses, okay, but that is not mandatory. That I have already told now, a nikah is to be signed. There is no such format of that, but it must be prepared in such a way that it is reasonable, enforceable by prevailing law, and not opposed by the policy of Islam. Understand? So these are the common essentials of Muslim law. Now, I will go to the rituals. There are pre-wedding rituals, wedding rituals, post-wedding rituals in every wedding and in Muslim wedding also. Although it is not mandatory, but it is there. Indian weddings are always elaborate. Indian weddings are always elaborate. In Hindu, Muslim, Parsi, Jain, everything is elaborate. In Muslim, Ijab-e-Kubul is most pivotal Muslim wedding ritual. Ijab Ijab means proposal and Kubul, Kabul hai. They have to say thrice, Kabul hai, Kabul hai, Kabul hai. Then the marriage is done. Second point is that for Muslim marriage, consummation of marriage must in Muslim law for completion of the marriage. What is consummation? The consummation of marriage is the first act of sexual intercourse between a married couple. This is required and it is compulsory. It has legal, religious, and cultural significance in Muslim society. Now, 2 points. A Muslim can take more than one wife at a time, provided husband can love and protect them, but not more than 4 at a time. Muslim men can take four wives at a time. However, opposite is not possible. Polyandry is not recognized in Muslim law. The practice of having more than one husband or male partner by an woman at the same time is not permissible. Male can marry 4 wives at the most, but female cannot do that. Now, funny thing is that before the Hindu Marriage Act 1955 was passed, Hindus could also take any number of wives without any limit. That is polygamy. Before that Hindu Marriage Act is passed, Hindu male can marry any number of wives. We all know that the great social reformer Ishwar Chandra Vidyasagar Mahashaya fought to restrain the idea of Bahu Bibaho in the society. Bahu Bibaho, Ishwar Chandra Vidyasagar fought for that. Now, registration of Muslim marriage. Muslim law does not actually require the registration of marriage as a mandatory requirement of valid marriage. In the same manner, Muslim law does not expressly prohibit the registration of marriage also. Registration can be done, may not be done. So, if any Muslim wants to get their marriage registered, that can be done under the Muslim Personal Law Application Act 1937. So, this is Muslim marriage law. Now, going to the other marriage laws like Special Marriage Act, Christian Marriage Act, Parsi Marriage Act, Foreign Marriage Act, the condition of marriage are similar to those of Hindu Marriage Act, except the condition for Shopindo relationship. There is a difference of Hindu Marriage Act and Muslim Marriage Act, but the other Marriage Act are similar to Hindu Marriage Act. Shopindo, that is Shogotro, it is not there in other marriage acts. Others are equal. Age limit, consent, like that, they are equal. So I shall not repeat the conditions of marriage while discussing these acts. I shall go through the essential procedure and ceremonies only in these cases. Special Marriage Act. The Special Marriage Act was passed in 1954. It was passed with an intention to regulate marriage between two individuals of opposite sex, irrespective of their caste or religion. That is the main thing. Hindu, Parsi, Jain, they are the personal law. But here, irrespective of caste and religion, it applies to the whole of India except the states of Jammu and Kashmir. It mainly deals with the intercaste, inter-religion marriages. It also applies to Indian citizens that lived abroad. That is also applicable. Now, what is the essential procedure of this act? This is mentioned in chapter 3. 1 month's notice must be given by the parties intending to marry, and after expiry of 30 days from the date of publication of such notice, the parties must go to the marriage officer, okay, appointed under Special Marriage Act, and fill up the form. 30 days notice is to be given, and after that, they have to go to the marriage officer and fill up the form. Make a declaration in presence of 3 witnesses that they have to give a declaration. I take thee to be my lawful wife, or I take thee to be my lawful husband. That is the declaration they have to give. The parties shall sign the declaration and 3 witnesses also sign. Then the marriage registrar will sign on it. Issue of marriage registration certificate. A certificate is issued by the marriage registrar. That marriage registration certificate is the conclusive proof of solemnization of marriage under the Act, and it only be challenged on the ground of fraud and representation. If there is a fraud or misrepresentation by any one of them, then that can be challenged. Otherwise, marriage is over. Now, 2 points I will mention here that is very important. Please note of that. While issuance of marriage registration certificate is conclusive proof of solemnization of marriage under Special Marriage Act, I have already told that issue of marriage registration certificate under Special Marriage Act, that is a conclusive proof. But certificate of registration under Section 8 of Hindu Marriage Act 1955 may be challenged on the ground that no essential ceremonies are performed as required under the said act. If no essential ceremony is done, then only registration is done under Section 8 of Hindu Marriage Act, that can be challenged. That is, along with the registration certificate, performing the essential ceremonies is also essential for conclusion of marriage under Hindu Marriage Act. Moreover, marriage solemnized in other form, whether under Hindu Marriage Act, Muslim Marriage Act, Parsi Marriage Act, Christian Marriage Act, that can be registered under Chapter 3 of Special Marriage Act afterwards, any day. And such marriage shall be deemed to have been solemnized under Special Marriage Act 1954. But here in this case, any children born to the parties before such registration under Special Marriage Act shall be deemed to be legitimate, eligible for inheritance. I like to interpret it in some other way. Suppose couple was married in 2000 in any of the marriage law, Hindu, Parsi, Christian, but at that time they have not registered the marriage, so no certificate is there. And at 2005, a child was born. Now at 2024, they need a certificate for some reason or other. So what they can do? They can go for the Special Marriage Act 1954 again, and they shall marry under the Special Marriage Act, and their marriage will be deemed to have been solemnized under Special Marriage Act 1954, and they will get the certificate, their purpose will be fulfilled. But what will be the fate of that child? Yes, that child is legitimate and eligible for inheritance. That is the speciality of Special Marriage Act. So this is Special Marriage Act. Now I will go to Christian Marriage and Divorce Act. In India, Christian marriage was introduced when Britishers came to India, or simply it was started in British era, enacted as the Indian Christian Marriage Act 1872. And after that, Act of 57 was in force. There is a time of solemnized Christian marriage. Christian marriage can be solemnized only between time interval of 6 a.m. to 7 p.m. We see that in Hindu marriage also, Lagno system is there, isn't it? Lagno, good time as per Shastra, is obeyed by Purohit and family members. Now, what is the place of solemnization of Christian marriage? The marriage only solemnized at a church where worship is generally held in form of the Church of England. Church of England. Their marriage is to be done, but when there is no church within a 5 miles distance, then special license is permitted to the minister of that church, nearby church, to solemnize the marriage at any places within the rules and rights of the church. That is stated in section 12 to 26. This is Christian Marriage and Divorce Act. Now, Parsi Marriage and Divorce Act. It is also same, conditions are same. The Parsi marriage solemnized according to the Parsi form of ceremony called Ashirvad by a priest in the presence of 2 Parsi witnesses. Other than such priest, 2 witnesses are required. If registration is done, copy of the certificate of marriage is to be sent to Registrar General of Births, Dates and Marriages. And there are various interesting pre-wedding rituals, wedding rituals and pre-wedding rituals of Parsi marriage also. Okay, so all these marriages, there are rituals. Some are contextual, some are sacramental, but rituals is there in all Indian marriages. Now I will go to the Foreign Marriage Act. What is the objective of this Foreign Marriage Act? The basic objective of this act is to solemnize the marriage between Indian citizen and foreigners. Indian citizen, another is foreigner. This act bridges the gap between the Indian marriage laws and foreign marriage laws and has some exclusive provision for citizen as well as non-citizen in India. In India, such marriage was governed under the Foreign Marriage Act. One citizen and another is foreigner. So, for that reason, Foreign Marriage Act was enacted. After declaration of the marriage, marriage is done, a certificate of marriage is issued under section 14 of the Act. The certificate shall be signed by the parties and the 3 witnesses. The marriage certificate is a piece of conclusive evidence that marriage has been conducted as per the rules and regulations stated in the Act and shall now be acceptable as per the law of the land. If Indian citizen and a foreign citizen marry and the certificate is with them, then that is applicable to the India and abroad, like that. So these are the laws which are enacted, which exist in India. Now, what is the law that is required? That is the matrimonial rights for LGBTQIA in India. Lesbian, gay, bisexual, transgender, queer and intersex asexual. In fact, same-sex marriage is not legal in India as yet. Although members of the LGBTQIA community also refer to the community of sexual minorities in India were given the rights to enjoy the same sex or non-heterosexual relationship. That right is there with them. But marriage between such consenting adults is deemed to be unnatural. They are enjoying the rights but of same-sex relationship, but marriage is not is said to be unnatural. So that appeals are filed in different high courts by married gay couple demanding for legal legitimacy of their marriage. And the courts have notified the central as well as state government on the same. There are so many cases in different high courts. And after that, as a consolidation, on October 17, 2023, the Supreme Court of India unanimously ruled against legalization of same-sex marriage. Against, the court left the decision to the parliament or state legislature to enact their own laws. The court did, however, reiterate the rights of LGBTQ citizens under the Indian Constitution. But they have not given any guidance or they have left the thing to the political parties or legislation like that. So, besides judicial decision, the issue of such legalization of same-sex marriages demands a political will. Thus, the role of legislature and the executive becomes important as the inclusion of such marriage will call for a revamp in the existing marriage laws. So here in this case, enactment of proper law is need of the hour. So there is no law for LGBTQIA group. So it is the required, it is the need of the hour. So these are the marriage laws exist and not exist in India. I have discussed in short because they are long process. I have given you the overview of this. Now I will go to the scenario on prohibition of child marriage. It is very interesting and important issue. Who is a child? The question is that, who is a child? The definition of a child varies across different enactments in India. The Indian Majority Act 1875, it defines a child as someone under the age of 18, unless a specific law for that child defines otherwise. Child Labor Prohibition and Regulation Act 1986 defines a child as someone who is under 14 years old. Juvenile Justice Care and Protection of Child 2000 defines a child as someone under 18 years old. Here we see that the age limit of child is mentioned differently in different laws, but same irrespective of their gender. Meaning boys and girls, same age is mentioned here. But in biological sciences, a child is typically defined as someone between the birth and the puberty. It is a biological science, the definition of like that. However, as we are going to discuss about the child marriage, we will go through the related law. Child marriage means a marriage to which either or both of the contract parties are child. That means the marriage is solemnized, one or both of them are child. One or both of them are child. So that is child marriage. To restrict the age limit of the parties, one act, namely the Child Marriage Restraint Act, which was enacted in British era long back in 1929 by the then Imperial Legislative Council. So law was there. According to the act, minimum age of eligibility of marriage was for a boy was 18 years and girl was 14 years. However, some age limit was there. After that, in 1978, the act was amended and age limit was raised for boys 21 years and girls 18 years. This age limit is still existing. The said act, that is I am told you now, that said act ultimately been repealed and a fresh new act, namely the Prohibition of Child Marriage Act 2006 has been introduced throughout India, where a child is defined as a person if a male has not completed 21 years of age, and if a female has not completed 18 years of age. Section 2A. The same in 1978, same age limit in as per 1978 Act. So that is the main thing. Now, what is the basic feature of child marriage? According to Section 3 of the Act of 2006, every child marriage shall voidable. Every child marriage shall voidable at the opinion of the contracting parties who was a child at the time of marriage. Please note that in general, such marriage is voidable, not straightway void. That is the main thing. If no objection or complaint is there, the marriage will automatically be valid when both the couple get majority as per law. There is one thing. But if the parties, that is husband and wife, wants for a nullity, they can file petition for the decree of nullity. Up to what age? The boys up to 23 years, 2 years after attaining majority, and for girls 20 years. Up to that age, anyone then can file a petition for decree of nullity of that marriage. But after that, they can apply for divorce, not for nullity. They have to go for the divorce act, divorce portion of the act. A marriage of a minor child only to be void. There is a provision only to be void when a child, number one, is taken out of the lawful guardian. That is, the marriage is given by the unlawful guardian. Is forcibly compelled to marry by anyone, is forcibly compelled to marry, not with their consent, and is sold for the purpose of marriage. Third one is sold for the purpose of marriage. For these cases, 3 cases, taken out of the lawful guardian, forcibly compelled to marry, and is sold for the purpose of marriage, the marriage is void, straightway void. Otherwise, it is voidable. That can be void. That can be, as per law, that can be a marriage automatically valid when they got majority. Now, there is a provision of punishment also. There is provision of punishment laid down in section 9 to 11 of the Act in 2006 in the following cases. Some cases are there where the provision of punishment is there. What are the cases? When a male adult marrying a girl child, male is adult and he is marrying a girl child. So the male adult is punishable. Whoever performs, conducts, directs, abets any child marriage, that is, purohits, parents, they perform the child marriage, they are also punishable. And any person or organization or association having charge of a child does any act to promote the marriage, permits to be solemnized, or negligently fails to prevent it from being solemnized. That means some NGO or something like that, they promote the child marriage or negligently fails to prevent, they are also punishable. These 3 cases, they are punishable. Above one shall be punishable with rigorous imprisonment, which may be extended to 2 years, and shall also liable to fine, which may be extended up to 1 lakh rupees. 2 years imprisonment and 1 lakh rupee fine. But according to this act, no woman shall be punishable with imprisonment. That they can be punished with fine only. And every state government appoints child marriage prohibition officer, who is deemed to be a public servant. And they have the duty to prevent solemnization of child marriage, create awareness, sensitize community on the issue, and related functions. Okay. And further, there are provision of child line, child welfare committee who are supposed to take care of pleasant and purposeful child life. Listen, in spite of such strong and useful legal protection and various social reform actions taken by union government, like Beti Bachao, Beti Padhao, and by West Bengal state government like Kannasri, Rupasri, and so on, crisis of girl-child marriage in India is acute. And as per National Family Health Service, it is more acute in West Bengal. Survey of 2019-21 reveals that districts like Murshidabad and West Midnapur are amongst the topmost districts in India in minor and early pregnancy. You see, 3 amongst 5, topmost 5. And percentage are much higher than the national average. According to the survey conducted through 707 districts pan-India, it reveals that 13 are such districts where 60% of the girls are given marriage before 18 years of age. 60%. Among these 13 districts, 9 are from Bihar and 3 are from West Bengal. In West Bengal, on an average, 41% of the girls are given marriage before they attain permissible age limit as per law. So, this is very alarming. Now, what I want to say, you see, here in West Bengal, history speaks that eminent scholars and social reformers like Vidyasagar Mahashaya, Rabindranath Tagore, Swami Vivekananda, and others have done great job against Ballo Vivaho and women education right from 19th century. They have worked, so many social workers and eminent scholars, they have worked for women education and against the Ballo Vivaho. And now also government of West Bengal provides 1,000 crores of rupees in every yearly budget. But this social anarchy is still alarming. Yes, it is also positive that percentage of minor girl child marriage is decreasing year by year. Although it is slow pace. And the elimination of child marriage by 2030 remains a priority under Sustainable Development Goal in India. So there is a try to eliminate, process to eliminate for girl child marriage. So there is a hope, there is a ray of hope. Let us see. Yes, poverty, illiteracy, dowry system, social customs, gender discrimination, safety security problem of female child, scarcity of job opportunity are among the many other reasons for which a section of guardians tries to get relieved from their responsibility of marrying the girl to a bridegroom at an early age. I have mentioned some of the reasons, even before the permissible limit, illiteracy, dowry system, social customs, like that. To come out of the situation, our government, our system, our society, our family, and individual we, in fact, should act proactively with continuous sincere effort to protect our lovely betis from this hazardous situation. Okay, this is the scenario of girl-child marriage. So let us sincerely hope that the beautiful event of marriage be more beautiful and life of each citizen be more colorful and meaningful as people follow the marriage laws of the land and enjoy the married life. Thank you so much for patient listening. And I also express my gratitude to the CEO of Modak Trainer Academy, Sri Ganesh Modak Sir, Dr. Gargi De Ma'am, and their vibrant team for organizing such an event in inviting me as a speaker. Namaskar.